Hi everyone, welcome to this session on private international law. Today we're going to look at when an Indian court will stay proceedings before it due to the presence of an arbitration agreement. To do so, we need to look at the Indian Arbitration Act of 1996, specifically Section 8. Essentially, Section 8 permits a party to a proceeding before a judicial authority or court in India to apply to that judicial authority or court to stay the proceedings before it on the basis that the matter before it is subject to an arbitration agreement and should therefore be referred to arbitration. There are a couple of points to note in relation to the wording contained in Section 8. 1. Note that the term judicial authority, though not defined in the Act, would cover any forum that acts judicially, that is, adjudicates disputes. Thus, one can ask for a stay of any judicial proceeding brought in breach of an agreement, even if those proceedings are not before a court as such. Thus, one can ask for a stay of any judicial proceeding brought in breach of an agreement, even if those proceedings are not before a court as such. 2. One should note that timing is important in making such applications. The right to ask for a stay of judicial proceedings brought in breach of an arbitration agreement may be lost if the applicant has participated in the judicial proceedings, that is, has submitted his first statement on the substance of the dispute, written or oral. 3. The applicant, that is the party asking the court to refer the parties to arbitration, must furnish an original or certified copy of the arbitration agreement on the basis of which it is making an application. The judicial authority may make a basic inquiry as to the nature of the dispute, the scope of the arbitration agreement, and whether the parties to the dispute are parties to the arbitration agreement, so as to determine whether or not the action before it relates to a matter which is the subject of an arbitration agreement. However, going by the plain meaning of the language in Section 8, the judicial authority is not permitted to determine any jurisdictional issue at this stage in relation to the existence or validity of the agreement or the arbitrability of the dispute. If an agreement is produced before it, it must refer the parties to arbitration as per the agreement. Now note that the rules outlined above in relation to Section 8 apply to arbitration seated in India, that is, arbitration whose legal situs is in India. And as we will study in greater detail in Unit 8, the seat of an arbitration will usually be expressly set out in the arbitration agreement produced before the judicial authority. If it's not, the judicial authority can try and determine the seat by looking at the implied choice of the parties by interpreting the arbitration agreement, or work out the jurisdiction with which the arbitration as a whole has its closest connection and determine this to be the seat. Now, what about foreign-seated arbitration agreements? Will an Indian court stay proceedings before it when it has an arbitration agreement with a foreign seat? The answer is yes, and is set out in Section 45 of the Indian Arbitration Act of 1996. This section essentially empowers an Indian court to stay proceedings before it which deal with matters subject to a foreign-seated arbitration agreement. And not just any foreign-seated arbitration agreement, but one providing for a foreign seat which is subject to the New York Convention and has been notified by the central government in the official gazette. An important point to note with respect to Section 45 is the scope of judicial review it permits. Unlike Section 8, Section 45 allows the court to make an examination of the jurisdictional question of whether the arbitration agreement is null and void, inoperative, and incapable of being performed. Now, the court has to apply the proper law of the arbitration agreement to determine whether the arbitration agreement is null or void. The proper law of the arbitration agreement, as we discuss further in Unit 8, is rarely specified by parties in their arbitration clauses. In the absence of an express choice, how will Indian courts determine the applicable law? The answer to this question is found in the Supreme Court case of NTPC versus Singer. Here, the court held that in the absence of an express choice, the inquiry must then proceed to the implied choice of the parties. And where there is an express choice of the governing law of the underlying contract or dispute by the parties, then this law is automatically presumed to be the implied choice. Applying this law, whatever it turns out to be, court must then determine the question of whether the arbitration agreement is null and void, inoperative, and incapable of being performed. If it determines this question in the negative, that is, the arbitration agreement is found to be valid and enforceable, the court must stay the proceedings before it and ask the parties to arbitrate the dispute as per the arbitration agreement. That concludes our discussion of stay proceedings to enforce arbitration agreement. Thank you for watching.